Day 2 of the public hearings at the International Court of Justice in The Hague in the matter between South Africa and Israel concluded yesterday following the South African legal team's calls for an immediate ceasefire in Gaza. Israel says that South Africa painted a very distorted picture and that it ignored the events of Saturday, the 7th of October. Now, the proceedings will resume next week when the 15-member bench of the court is set to make a decision. Let's speak more about this with public law senior lecturer at the University of Johannesburg, Dr Swikani, Ncube, and international relations expert Dr Kingsley Makhubela. Gentlemen, a very good morning to you both. Welcome to Newzroom Afrika. Perhaps, Dr Makhubela, let's start with you. In South Africa's landmark case against Israel, the South African lawyers are essentially asking for the court to order an immediate halt to Israeli military operations. In your assessment, what have you made of the deliberations so far in court?
Good morning. This case, as I always maintain, it really depends on technicalities. And these technicalities, they revolve around the jurisdiction of the courts to hear the substantive matter. Now, Israel has made a presentation that really says, in terms of Article 31 of the statute, there's no dispute. Because the ICJ can only listen or hear the matter once there's a dispute and arbitrate around the interpretation of the statute. And they are saying it doesn't exist. That's a huge thing that Israel came up. South Africa tried to present a paper trail that indicates there's been communication with Israel to try to resolve this interpretation. And that hinges on the non-verbal of the 21st of December. But the question is what transpired between the 21st of December and the 29th of December when South Africa took the matter to The Hague. And Israel contends that South Africa tried to deal with paperwork after realizing that there's no dispute. And it argues that dispute is not a unilateral action. It must be a joint action. And as far as they're concerned, there was no dispute, and there's no proof for that. So that's the technicality that is so major in terms of this case.
Yeah. Dr. Ncube, Dr. Makhubela speaks about technicalities, depending on technicalities. What would you say form the merits of this very substantial case?
Good morning, Paul, and good morning to Dr. Makhubela. I think when one looks beyond the technicalities on the merits, really, particularly considering the fact that at this point, what South Africa needs is not so much to prove genocide, but the risk of genocide. I feel the team did a good job because they zoomed in, particularly when one looks at Advocate Ncube presentation. They zoomed in on the issue of intent and really tried to link the statements by the Israeli leaders and the conduct of their soldiers on the ground. Now, when one looks at the definition of genocide from the convention and the need to prove intent, they were aware of that, and that it's a requirement that they would have really needed to tick that box and ensure that it's very clear why they are alleging genocide. And on that score alone, I think they did very, very, very well. Particularly one video that Advocate Ncube played that showed soldiers dancing and singing, and within their chants was a statement, there is no innocent civilian. I thought that was huge.
Israel, on the other hand, Dr. Makhubela, has vehemently denied the accusations brought by South Africa. In fact, Israel's gone as far as saying history will judge South Africa for abetting the modern heirs of the Nazis. How should we interpret such a position?
What Dr. Ncube is saying, it's so fundamental. The question of really proving the intent to commit genocide. It's so difficult to prove the intent. It's a daunting task for South Africa. And Israel came out to rebut this argument and utterances of statement by different people, military people, senior government officials. I mean, advocate Galit Ragwan was quite emphatic that indeed there have been abuses that are committed by the military. And there are systems and processes that are intended to prosecute them because they understand their responsibility in terms of war crimes and so on. And she went on to argue that this would not necessarily constitute genocide because there are systems to deal with it. The Attorney General actually, I think, was too strong. When he came out to indicate, the Deputy Attorney General, to indicate how the Israeli system is, the independence of the prosecution and the judiciary. And no one can doubt that. The independence of the Israeli judiciary system is so robust. And he went on to indicate that indeed people may have uttered statements that are not in line with the values of Israel, and that there's a process to investigate and take appropriate action against them. If we go back to look at the judiciary system, they have actually, it's the only country that they will go and raid the Prime Minister's office, the sitting Prime Minister, to look for evidence. And they would compile and take evidence from the sitting Prime Minister. So in terms of the robustness of the system, I think he conveyed a very strong message to the bench as to what they are doing about the abuses that may be there. But they continue to argue that this does not constitute genocide. And that's where it has been very difficult for South Africa, really, to come up with really during this initial stage, because this is not the stage where they argue the merits. They looked into the systems and so on. But I think Israel was quite strong, and this case can go either way. South Africa made, as Dr. Ncube said, made a very strong, compelling case in terms of the substance of the case. Yeah. And it will be very difficult for anyone to repudiate killing of children and so on moving forward.
Dr. Ncube, we know that this decision will take a few weeks, though the full case is likely to take years, lasting years on end. What important decisions will be made in the next couple of weeks, and how that could bring some relief to Palestinians if the court rules in favor of South Africa?
Well, for starters, Paul, my worry is that Israel took this stage more like to sanitize what they've been doing. They saw this and interpreted it more as a platform to try and push their propaganda. And my feeling is that if the decision goes against them, they'll just disregard it. And that has been Israel throughout their conflict with the Palestinians. So when one looks at what South Africa is presented now and what they've requested from the court, these are called provisional measures. And for the benefit of our audience, these are temporary measures. And what South Africa has to prove now is not that there's genocide going on. It's that there's a plausible risk that genocide may occur. And on that threshold, I would be very reluctant to think that a court in its right senses would find otherwise, because the evidence is such that there is a reason to at least exercise caution. So if they decide against South Africa's request for these provisional measures, then the bombardment and killing that we have seen continues. And South Africa was very clever to even put the numbers in there and say 247 or 248 people are killed every single day. Of those 247 or 248, 117 are children. So if South Africa succeeds, particularly in relation to the first request, it would be to hold all the military activity going on. And that provides the relief for the Palestinians, particularly for aid. And let's not forget that while we may focus on the killing from the bombs and the shooting and the warfare going on, another big concern is the destruction of the health system. And that on its own means those that are injured, those that are sick, those that have contracted diseases as a result of lack of clean water and various other conditions are themselves going to be at risk. And it is that condition that really brings the issue of really an intention to destroy in whole or in part. And I've said at this point in time, if you ask me, Paul, I would not say in whole, but certainly in part.
Yeah, absolutely. You speak about the destruction of a healthcare system, but we also know what's come out very strongly is the prevention of Palestinian births, which has also been one of the legal arguments put by South Africa, Dr. Ncube, saying that Israel is blocking the life-saving treatment needed to deliver babies, and that in itself amounting to preventing births in Gaza.
Certainly, in those considerations, when you look at Section 36, Article 36, that is, of the ICJ statute, it says the existence of a fact, let me just read it out quickly, the existence of any fact which, if established, would constitute a breach of international law. And that right there is a breach of international law. Just like Advocate Toby was saying, listen, if somebody says, let's not give them electricity, let's not give them water, let's block aid, what do you think will be the reason, really? It doesn't need any scientific inquiry to ascertain what the result would be. You and I can tell, well, if water does not go in, if electricity is not provided, if aid does not go in, these people will die. So all the conditions that you and I are discussing now, the births and so forth, it's simply a result of an action that was intended. And for that reason, for me, on that score alone, there's really a basis to accede to South Africa's request for these provisional measures.
Yeah, absolutely. Dr. Makhubela, several countries and international organizations have rallied behind South Africa in its case. Malaysia, Turkey, Bolivia are among them. How could this battle impact South Africa's ties with the West?
Well, you know, the fact that these countries have made public pronouncements and did not become party to the ICJ dispute on the matter is neither here nor there, because that's not going to be considered by the court. The court would have considered this if they were party to it. You would realize during Israel's presentation, there was an underlining tone that really says South Africa has no understanding of the dynamics in the area, that Israel is working with countries in the region to provide humanitarian support and so on. Had these countries really been part of the court, it would have bolstered South Africa's case in terms of dealing with the numbers, the sheer numbers of countries that are outraged and that are willing to become party to this. But we know how the system, the global system works, both the American and the Israeli system, in terms of blackmails and threats that are made to countries that are standing up to these big powers around the world. So that's why you didn't see any hand raised. South Africa remained alone, and no one came to join the case, and I think it would have been better if they did that.
And very quickly, while it's all good and well for South Africa to support and steer this cause, what is essentially in it for South Africa on the opportunism front and politics front?
It's basically the question of values. I think as countries should stand up for their values, irrespective of how the mighty and powerful are. And I think it really underlines the importance of the reform of the whole power distribution systems around the world, because the unipolar world has become very dominant. What is wrong for A is not necessarily wrong for B, and that has created a huge problem. I think there's a need to really relook at the system, and that's where South Africa is. South Africa is already punished now, I think. You realize South Africa did not manage to get voted into the Human Rights Council. And I think countries that are really opposed to this independent South African stance around international issues, they were not comfortable, and they couldn't support South Africa in that. I think we are likely to see other areas where South Africa would definitely be sidelined by bigger powers, but I think South Africa should stand up to what it believes.
Yeah, absolutely. Thank you so much, gentlemen. Let me thank you both for your time. That was Dr. Kingsley Makhubela, who's an international relations expert as well as senior lecturer at UJ Public Law, Dr. Swikani Ncube, speaking to us there and just weighing in on the developing story around the ICJ matter put by South Africa.